matter PZ 24-0097. It is now 7:44. This code enforcement matter was heard by the county's hearing officer, Howard Brown. Mr. Brown
Mind
made
you that
findings
Howard
of
Brown
fact
is
and
merely an
conclusions of law
attorney.
and
He's not a
determined that the
magistrate.
property
This is
owner,
an administrative
Church of the
law
Common
judge,
Good,
or
was
ALJ.
responsible for certain zoning violations, provided the owner 30 days to remedy the violations, and set out sanctions if the violation was not remediated by the deadline. Property owner, Church of the Common Good, has appealed this decision to the board according to the procedural
It's
rules
Church of
contained
Common
in
Good.
Chapter 5
Get it
of the
right.
Coconino County zoning ordinance. I would like to recognize the parties. Would the parties for the Church of the Common Good please announce themselves?
Can you hear me? This is Pastor Andrew Stevens.
Yes, we can. Thank you. Let's see.
I have another board member here, Virginia Van Zant. She's here watching. I don't think she understands how to speak. She doesn't understand how to speak.
Mr. Chair, we will bring her in.
We'll get to that point. We're still not quite there yet. But thank
They
you.
never got to that point.
Next week, Mark Stento will appear on behalf of Coconino County Development Board. Okay, yeah, the board has received and had the opportunity to review the record in the case, as well as the memoranda timely submitted by the parties. At this time, I will advise that each party will have 10 minutes to present their position. This amount of time has been communicated to the parties in advance. Parties are reminded to keep their statements focused on the hearing officer's decision and the evidence that was presented to the hearing officer. Any evidence that was not presented to the hearing officer will not be considered. The board will hear from both parties on this matter. This will conclude any opportunity for input from the parties or the public. Following both parties' presentations, the board will deliberate amongst ourselves, but no further input or comments from the parties or public is allowed.
So what he's saying is I can make my statement, then Mark Stento gets to argue and rebut that statement, and there is no going back to me being able to rebut anything he said. Whatever he said is, I guess,
I
fact.
just want to start and make
So this lady they bring in to instruct them how they can't even have their own opinions, just whether the guy committed abuse or not.
in a matter, in this matter. This is a standard of review that is very different from what you may be used to in conditional use permit appeals and other items that come up from planning and zoning. The standard of review, the term is an abuse of discretion. So the board is
This is why the first opinion that matters is a judge.
whether the hearing officer abused his discretion in making his decision. It can help to understand what this means by considering what it does not mean. It does not mean that the board is hearing evidence and considering all that evidence on its own. The board is not substituting its judgment in place of the hearing officer. Excuse me.
Their mics are so bad I had to move the speaker close to myself.
That includes the evidence that was presented to the hearing officer, the decision of the hearing officer, and the statements that the parties will make tonight. And then decides whether the substance of the evidence supports the hearing officer's decision. It's certainly possible that a different conclusion could have been made as a result of the evidence. If two opinions can come from that evidence, that is not an abuse of discretion. An abuse of discretion occurs when there is no substantial evidence to support the hearing officer's decision.
So basically, your opinion doesn't really matter.
Thank you, Counselor.
It's whether the guy abused his discretion or not. It's so
Parties will make
limited.
their presentation to the board at the podium or virtually. Each party has 10 minutes. The lights at the top of the podium communicate time remaining. The speaker will have 30 seconds remaining. The clerk will announce 30 seconds. At 10 minutes, the red light will go on. Parties will cease their presentation at 10 minutes. Your time begins after I have called upon you and you begin your presentation. The Church of the Common Good as appellant will present first. So
You
your
ready for
10
it?
minutes has begun. Mhm.
Yes, Board of Supervisors. Good afternoon, Chair and members of the board. My name is Pastor Andrew Stevens, and I represent the Church of Common Good. Thank you for the opportunity to present my appeal today. In July of 2020, at the height of the COVID-19 pandemic, our church purchased a property under a land contract sight unseen. Because government buildings were closed at that time, we were prevented from obtaining a pre-site inspection or applying for any conditional use permit as we normally would when we buy a property. The deed was formally transferred into the church's name on April 1st of this year. By that time, however, code enforcement had already issued violations, effectively blocking us from pursuing the very permits we would have sought had the county been open in 2020. The initial evidence used against us was gathered before the church ever owned the property, during a welfare check unrelated to our ministry. Inspections have since been conducted without warrants or permission, amounting to trespass. The case again against us rests on facts that misrepresent the church's actual stewardship and religious use of the property. Our parcel is zoned general use, the least restrictive zoning in Coconino County. General use allows for agricultural, residential, and other mixed uses. The retreat lies 6 miles down a dirt road, far from neighbors or businesses. Even the county's own enforcement officer, Mark Stinto, admitted that general use zoning was the best available and that the retreat is indistinguishable in character from a campground or RV park, both of which are permitted uses. Congress enacted the Religious Land Use and Institutionalized Persons Act, or RLUPA, to prevent exactly this scenario, where government land use regulations substantially burden the free exercise of religion. Courts across the country have consistently ruled that churches cannot be excluded from land simply because of zoning restrictions. In Hume versus Planning Board of Monterey, the court protected a Christian camp against unjust zoning limits. In Elder versus City of Pueblo, the Christian Growth Center prevailed against municipal efforts to suppress their ministry. And in Church of the Rock versus Castle Rock, Colorado, courts again upheld the principle that zoning rules must yield when unlawfully burden religious practices. These cases affirm that unless the government can show a compelling interest pursued by the least restrictive means, restrictions that prevent a church from carrying out its mission cannot stand. Our retreat serves a very specific religious mission. 13 board members, all discipleship participants, follow Christ's commandment from Matthew 10. Take no gold, no silver, no copper, nor bags for your journey, nor even 2 tunics, or sandals, nor even a staff. Then they leave their possessions behind while traveling 9 months of the year for missionary work. The retreat provides them a modest sanctuary to store what they cannot carry and a place to return to for restoration. Guests may stay up for up to 14 days in line with federal dispersed camping guidelines, as seen on BLM land. Plus, ones of our board members may remain longer if they assist in the ministry. This is not a permanent residential subdivision. It is a religious retreat functioning as a sanctuary of discipleship and hospitality. We are also commanded by Christ in the parable of the Good Shepherd that what we do for the least of these, we do for him. Our ministry serves nomadic individuals, people who would otherwise have no safe or lawful place to rest in Coconino County, at least in Flagstaff, due to ordinances effectively criminalizing vehicle dwelling. The retreat fills that gap, offering dignity, safety, and spiritual care. In conversations, county staff suggested that in order to obtain a conditional use permit, the church would need to make a large economic investment as well as abate the property. And this investment would be in infrastructure. That infrastructure would significantly diminish the natural and spiritual character of the retreat. For us, this is not merely a financial matter. Our doctrine teaches us to avoid usury and unnecessary debt. And more importantly, we believe that the retreat's religious and natural aspects are integral to our ministry. Imposing costly infrastructure demands transforms a place of simplicity, discipleship, and spiritual refuge into a commercialized facility that is incompatible with our religious ministry and constitutes a substantial burden under our LUPA. Our retreat is not a health or safety risk. We have implemented proactive measures that exceed county expectations when it comes to RV living. Board members on RVs here are mandated to be modified and comply with ADEQ standards, including composting toilets and separate reservoirs for kitchen black water and shower sink gray water. We are installing a large composting system to serve guests without compliant toilets, and Winslow is only 6 miles down our one dirt road. And they have potable water and black water transfer stations right in town. During the winter, when irrigation is not possible, gray water is safely stored in reservoirs. These systems protect both public health and the environment. The county has presented no evidence of contamination, no complaints from civilians, or harm to neighbors. Instead, the objections rest primarily on aesthetics, and aesthetics, as the courts have ruled, are not a compelling interest under our LUPA. Neither are tax burdens or property value. By prohibiting us from allowing temporary RVs or guest dwellings on our own property, the county is directly preventing us from carrying out our religious mission. Our ministry cannot function without the ability for board members, traveling missionaries, and guests to dwell temporarily in simple mobile shelters. Without this allowance, we are effectively shut down. That is the very definition of substantial burden under federal law. Members of the board, this is not merely a land use dispute. This is a matter of religious liberty. The Church of Common Good is not seeking special privileges, only equal treatment under the law, consistent with our LUPA and with the principles of justice this nation holds dear. Our ministry exists to serve, uplift, and obey God's word. Denying this appeal would not only impose a substantial burden on our exercise of faith, but it would also set a troubling precedent for how religious ministries are treated in Coconino County. For these reasons, I respectfully urge you to overturn the hearing officer's decision, allow our ministry to continue, affirm that religious freedom and equal protection still matter in this county, and allow us to seek our conditional use permit as we would have in 2020 had the government been open. Thank you for your time and consideration. I'm done.
Thank you. Now, Mr. Cento of the Coconino Community Development Party will present.
I can't hear him.
It is now. Good evening, Vice Chair, members of the board. My name is Mark Stento. I'm the Compliance Manager for Coconino County Community Development. I'm here this evening to address the appeal of case PZC 240097 for 47775 BNSF-RR Road. This case is straightforward. It involves unpermitted RV dwellings and outdoor storage of refuse and operable vehicles and secondhand materials on a G-zoned residential parcel in Coconino County. Both occupancy of an RV and outdoor storage are, of course, regulated by the county zoning ordinance. The hearing officer carefully reviewed the evidence, made credibility determinations, applied the law, including the Religious Land Use and Institutionalized Persons Act, or RLUPA, and entered a reasoned order. That decision should be affirmed this evening. Here are the facts. Inspections over 8 months, which were initiated after a report from the Coconino County Sheriff's Office alleging unsafe conditions, documented the same violations repeatedly. Photographs, exhibits, and firsthand testimony confirm the presence of occupied RVs, trailers, and makeshift structures used as dwellings. Statements from RV occupants who alleged association with respondent, as well as admissions from Mr. Stevens, established that people were and are staying on the property overnight, often continuously. JMC Land, owner of the property prior to transfer to respondent, acknowledged respondent was under contract to buy and use the land at the time of initial complaint and investigation. The county zoning ordinance defines an alleged violator as a person, natural or corporate, responsible for a property which the zoning inspector or code enforcement officer has reason to believe a violation of the zoning ordinance exists, including but not limited to the owner or tenant for the subject property. Photographs also show unscreened storage of construction debris, such as railroad ties, refuse, tires, and inoperable vehicles. While some cleanup has occurred, violations persisted as of the July 10 hearing. Community Development provided multiple notices and opportunities to correct these violations before bringing the matter to a hearing. After testifying to these facts at hearing, supported by the exhibits on the record, the hearing officer found my testimony credible. However, he found that Mr. Stevens, who testified on behalf of respondent, provided contrary testimony when he stated that the vehicles were operable and no one was living on the property. The hearing officer found this to be implausible in light of the evidence. Moving on to the legal framework of the case, under Arizona law and the Coconino County zoning ordinance, on appeal of a code enforcement case, the board reviews decisions of the hearing officer for abuse of discretion, error of law, or lack of substantial evidence. None of those apply here. The order is fully supported by the record. The violations are clear. Coconino County zoning ordinance sections 317C and 317D prohibit the use of one or more RVs or travel trailers used as a dwelling in a G-zone parcel without proper permitting. By Mr. Stevens' own admission on the record, people may stay on the subject property for up to 2 weeks or overnight, and at least one person may stay on the property every night. No lawful dwellings nor a permitted recreational vehicle in which habitation may lawfully occur have been documented on the property. Sections 47C1A and 47C1B of the zoning ordinance prohibit outdoor storage of refuse, inoperable or unregistered vehicles, and secondhand materials. Exhibits included in the record clearly show outdoor storage of these items on the property prior to the July 10 hearing. As demonstrated in the record, respondent is in violation of both provisions of the zoning ordinance. However, despite their claims to the contrary, respondent has not been cited for or denied a permit to operate a campground or a religious retreat. Respondent has also alleged applicability of cases including Hume Christian Camp v. Planning Board of Monterey, Church of the Rock v. Castle Rock, and Elder v. City of Pueblo, as well as the Massachusetts Dover Amendment. These are not relevant to this administrative appeal hearing for land use violations in Arizona because they involve out-of-state and out-of-circuit law that is not binding in Arizona or the Ninth Circuit. Additionally, both the Church of the Rock and Elder cases settled out of court. The district court never made a final ruling in either case. Hume Christian Camp arises under Massachusetts law and addresses issues of religious land use or zoning interpretation not applicable to Arizona's statutory scheme or the specific enforcement of county zoning ordinances. The respondent relies on RLUIPA, but RLUIPA does not create a blanket exemption from zoning laws. Courts across the country have been clear religious entities must comply with neutral, generally applicable zoning requirements. For example, in Civil Liberties for Urban Believers v. Chicago, specifically referenced in Mr. Brown's order, the Seventh Circuit held that land use regulations of general applicability that do not effectively prevent religious exercise do not impose a substantial burden under RLUIPA. So I'd like to make 3 points. One, there is no substantial burden. The order does not prohibit worship, baptism, or ministry. It requires only that occupancy of an RV be properly permitted and that outdoor storage be removed. Respondent can minister freely while complying with these neutral requirements. Even if there were a burden, the requirements serve compelling government interests protecting health, safety, welfare, and environmental quality. Enforcing basic zoning is the least restrictive means of achieving these interests. Equal treatment has occurred. Community development applies the same rules to religious and non-religious property owners alike, and there is no evidence of discrimination or unequal enforcement in this case. Respondent has cited Colorado cases involving churches hosting the homeless. Those cases are factually and legally distinct. They involve specific findings of arbitrary exclusion or direct restrictions on ministry. Here, by contrast, respondent may gather, worship, and minister without interference. They simply must comply with the same zoning rules as every other landowner in a G-zone property. Finally, the order itself is measured and reasonable. At the request of community development during the administrative hearing, respondent was given until August 13, 30 days to comply. I'd like to reiterate that we asked to give them more time at the initial hearing. In the event of noncompliance, potential civil sanctions were modest, $20 per violation per day, capped at $1,500, and have not even been applied as respondent's appeal of the hearing officer's order occurred prior to the scheduled recall hearing. So again, no fines have been applied. The intent of the hearing officer's order and community development's administrative action is corrective. We are trying to gain compliance. It's not punitive. So summarizing, substantial evidence supports the findings. The zoning ordinance was applied lawfully and neutrally. RLUIPA does not shield respondent from compliance, and the order is reasonable and proportional. So members of the board, this case is not about religion. The county zoning rules apply equally to all property owners, regardless of their purpose, to ensure public health, welfare, and safety. The record shows clear ongoing violations. The order gives the respondent every opportunity to comply, and nothing in the order prevents them from worshiping or ministering. For those reasons, we respectfully ask that you affirm the hearing officer's decision. Thank you.
Thank you. We have now heard from the parties. I will turn it again to Attorney Winkler to lay out the process for our deliberations.
Thank you, Vice Chair Vasquez.
Now listen to her tell everybody how they can't rule about their own opinion at all.
I just
Again.
want to note, as I believe Vice Chair Vasquez, you already stated, that deliberation is only among the board members and will not involve any further statements from the parties or any questions posed to the parties. Though I also then want to address how a board member should frame their motion when they are ready to make one. The motion, the first decision for the board, is regarding whether the hearing officer abused his discretion in making his decision in this matter. So the initial motion by any board member will be either a motion to hold that the hearing officer did not abuse his discretion, or a motion to hold that the hearing officer did abuse his discretion. If that motion is seconded, the chair can then call for a vote or hold any discussion prior to vote. If a majority of the board approves a motion to hold that the hearing officer did not abuse his discretion, then that is the completion and resolution of the appeal, and no more action from the board is necessary. If a majority of the board approves a motion to hold that the hearing officer did abuse his discretion, then according to the zoning ordinance, the board must make an additional decision, again, through the motion process. I can certainly go into that detail now. Vice Chair Vasquez.
Just to be clear, this is all performative. As you'll see, every answer these board members
Let's
give
go
will
ahead and
be
hold off and
almost
begin
like
with
is routine, like they're saying the
deliberations
same
among
thing, which is
board
nothing.
members. Are
It's
there
all
any comments from
performative.
board members
It's
at this
administrative
time?
court.
Supervisor
There is no
Ontiveros.
rules of court.
Thank you,
They're
Vice
just
Chair Vasquez.
putting on a show.
I want to state for the
Shakespearean.
record that I have read all the documents submitted for the Code Enforcement Appeal hearing for PZC 240097, as set forth in the table of contents in the board agenda packet dated September 23rd, 2025. I have heard and considered the testimony presented this evening by both parties, and I would like to make a motion to find that the hearing officer did not abuse his discretion.
Okay, we do have a motion. Are there any?
Chair
Go ahead.
Horseman has her hand up.
Oh, I'm sorry. Chair Horseman, please. Chair Horseman would like to second that motion. Are there any other comments by board members? Okay, in that case. Sorry.
I would like to make a comment, please.
Chair Horseman.
Just also for the record, I think this is important. I also have taken a look at the full record. I take a look at our standard of review, and this is a limited review for abuse of discretion, for error of law, or lack of substantial evidence. And so, like my colleague, Supervisor Ontiveros, I reviewed the full record, all the exhibits, the photos, the hearing itself. I listened to that about 90 minutes. Took a look at the decision, also the appeal statements from the appellant and Stevens, and also from Mark Stento. And after reviewing all of it and taking a look at our standard of review, I cannot find any type of abuse of discretion. And I do find that there is substantial evidence to withhold the decision of the hearing officer on this case. So it leaves one last area for us to review, and that whether there's been an area or an error of law. And taking a look at the materials presented, the cases presented, the Religious Land Use and Institutionalized Person Act, I agree with the comments that have been made. Looking at this and looking at the cases, I do not see, though I certainly recognized Pastor Stevens and his exercise, their religion. I do not find that their religious exercise is substantially burdened by the zoning that is the zoning ordinance and by the zoning requirements. I also find that this zoning ordinance and its requirement are for and serve a compelling government interest. I find that this compelling governmental interest is being done area. And so I do not find that there has been any violation or error of law. And that's why I made my second to Supervisor Ontiveros' motion. And I, for the record, wanted to state the reasons I am made my second.
Thank you, Chair Horseman. Are there any other comments from board members before we move forward? Supervisor Begay.
Thank you, Chair. I just want to say that, the Coconino County has zoning ordinances, policies, procedures that we do things within the county, and everyone is held to all the standards, and as far as making sure that they're adhering to these, especially in this case, the zoning ordinance. So I also feel that, that the hearing officer, made the right decision, and I do support my colleagues' motion and a second with this particular topic. Thank you.
Thank you. Supervisor Fowler, any comments?
Thank you. We did receive all the information that was necessary for us to review and the video. And so I did as well, to do our due diligence in learning about the case. And so I do also support I don't believe that the hearing officer made any violations.
Thank you. And then my comments as well, having reviewed the evidence and taken the time to look at all the different pieces and looking at really why we're here today, which is, did the hearing officer abuse their discretion in making this decision based on the evidence and the logical flow of the arguments that have been made? I believe that the hearing officer did not abuse their discretion, and so I am in support of this motion. So with that said, we have a motion on the floor. Do I need to read it out again, or are we good just with the motion?
I believe the motion's been made, and I think it's clear on the record what the motion is.
Okay, in that case, all those in favor, please indicate by saying aye.
Aye.
Aye. Any
Aye.
opposed? Please indicate by saying nay. Okay, make sure I get